Good morning and good afternoon if you're in the Central or East Coast time zones, and welcome to, I think it's the 11th webinar in the continuing series of Thomson-Coburn webinars this year. This morning we're going to be speaking about what's new in California for 2016. Okay, again, my name is John Viola. I'm a partner in Thomson-Coburn's Human Resources practice, and I've been practicing labor and employment law for over 35 years now. I started out as a New York lawyer, and as I get tired, perhaps you might hear some of that New York accent come out. So let's start with some good news, some legislation that was not enacted in 2016 by the California legislature. Back in October, Governor Jerry Moonbeam Brown vetoed two bills that were labeled by the California Chamber of Commerce as job killer bills. At least they were not enacted in 2016. And we'll see what happens when the person who's reputed to be next in line for the governorship, Gavin Newsom, the mayor of San Francisco, is governor. He may not veto these bills. So here's what may be coming down the pike in California. AB 465 was a bill that would have precluded mandatory employment arbitration agreements. Luckily, Governor Brown vetoed that bill. SB 406, also vetoed by Governor Brown, would have expanded the California Family Rights Act significantly and also created inconsistencies with the Federal Family Rights Act, just to make it a little more difficult for California employers. And this bill would have allowed employees to take additional leave for family members by redefining the term child quite broadly, well beyond that provided by California law. In addition, the bill would have expanded the definition of leave with regard to caring for people with serious health problems, and also to include leave to care for grandparents, grandchildren, siblings, or domestic partners with serious health condition. And in addition, this bill would have included a parent-in-law under the definition of parent. Further, SB 406 also would have reduced the application of the Family Medical Leave Act for employers with 50 or more employees down to 25 or more employees. So it was quite significant that Governor Brown, recognizing that the legislature is not doing a good job of retaining employers in the state of California, actually vetoed these bills. But who knows what's coming up when Brown finally retires and Gavin Newsom takes over. Here's another thing that did not happen in 2016. The Los Angeles Dodgers still have not won the World Series since 1988, and things are not looking good this year. Okay, so what was new for 2016 in terms of what was actually put into force and enacted by government regulatory agencies in California, and as well as by the legislature, and actually what was signed by Governor Brown and went into law for effect this year? The first one, perhaps of most significance, is the new FEHA regulations that were effective April 1st, 2016. And no, this was not an April Fool's joke. These regulations actually went into effect on April 1st. And under the new regulations by California's Fair Employment and Housing Authority, employers must implement written harassment, discrimination, and retaliation prevention policies, and they have to distribute these policies to all employees. What's more, the employees must acknowledge they've received and understood the policy. And under these new regulations, I mean, this is really common sense, but it's now part of the regulations and must be in your policy. Employers have to make sure that they create adequate methods for employees to bring complaints and methods for investigating those complaints. Many employers already have hotlines, for example, or are instituting hotlines so that employees can easily bring complaints. And also, employers who don't have procedures for investigating complaints are now trying to comply with these regulations by making sure they set up these procedures. These regulations require employers to create an investigative process that ensures that the complaints are designated as confidential, but to the extent possible, because of course you're going to need to talk to various people, various witnesses, victims, or perpetrators of acts alleged in a complaint. Employers must make sure that their investigation proceeds in a timely manner and that the complaint is responded to in a timely manner. The regulations require that the investigation is done by somebody who's qualified, that the people conducting the investigation document and track the investigation to ensure that reasonable progress is being made, and that adequate options are provided for remedial actions and resolution of the complaint so that the complaint can be closed in a timely manner. And as you know, a lot of employees are leery of making complaints because of they're afraid they're going to be retaliated against by their supervisors. So under the regulations, employers are to make sure that the complaint process does not require the employee to go only to his or her direct supervisor with complaints. You need to allow other venues to bring the complaint, such as a designated company representative, an ombudsperson, having a 800 hotline, or directly going to the appropriate state or federal agency. In California, the Department of Fair Employment and Housing, or under federal law, the EEOC. And it is adequate to simply have people file complaints with someone in HR. But again, the purpose of the regulation, the intent and the express language requires you to find another avenue for an employee to bring a complaint instead of going directly to his or her supervisor, or if you have multiple locations, to local management. Now, something new here is that in this regulation, the training requirements which apply to employers of 50 or more employees have also been updated. There are new documentation and record-keeping requirements, but as well, the regulations have new content requirements. In the training has to address the negative effects of abusive conduct in the workplace. And don't forget, in California, although not part of FEHA yet, we anticipate that soon anti-bullying will be part of the harassment regulations. And as things now stand, anti-bullying must be included in the training as well. The content requirements include that supervisors have obligations to report misconduct and that steps can be taken to correct and remedy harassing behavior. Now, through these new regulations, or I should say amendment to the FEHA existing regulations, the DFEH has provided for the first time details regarding what must be included in the harassment, discrimination, and retaliation prevention policy. So the policy, as we discussed earlier, must be in writing, must list all categories of individuals protected by the Fair Employment and Housing Act, and must specify that supervisors, managers, co-workers, and third parties who come into contact with workers are prohibited from engaging in conduct prohibited by the FEHA, including retaliation. As we discussed, the policy must create a complaint process that meets these requirements, including providing alternative avenues to bringing complaints. The policy needs to instruct supervisors to report complaints to a designated company representative so that the company can try to resolve these complaints internally if possible. And again, the policy must indicate to employees that the company will investigate all complaints in a fair, timely, and thorough manner. With respect to confidentiality, as we discussed, the company cannot promise confidentiality because you can't have confidentiality if you're going to conduct a thorough investigation. But you need to indicate in your written policy that confidentiality is going to be maintained to the extent possible. It also must state that if misconduct is found, appropriate corrective action and remedial action will be taken. And again, the policy must emphasize that anyone who brings a complaint, or moreover, people who participate in the investigations themselves, are not going to be retaliated against. Now, it's important that this policy be either in a separate writing or that you include the policy in your handbook, and that, as we discussed earlier, that you obtain acknowledgement from the employee that he or she has received, reviewed, and understood the policy. So the amendments require this and require that you distribute the policy using several methods that are allowed. First, you can have a hard copy of the policy, print it out, provide it to your employees, and provide them with an acknowledgement form for them to sign, date, and return, and keep that acknowledgement form in the personnel file. You can send the form by email with an acknowledgement of receipt form, but I would caution you, if you do that, to make sure you keep copies of the form and keep a method of ensuring that the person has received the form and that the person has actually electronically signed off on the form, because there is a case in California, a Court of Appeal case in 2015, that held an arbitration agreement to be unenforceable where the employer was unable to prove, to the satisfaction of the court at least, another issue of whether they're able to prove it, but were unable to prove to the satisfaction of the court that the employee had electronically signed the document. Getting back to the harassment policy, you can post it on your intranet with a tracking system to make sure that all employees have read the policy and acknowledge receiving it. You can discuss the policy at the time of the employee's hire or during an orientation session, or any other way that makes certain that the policy is received and understood and that the employee signs off on it. In addition, the amendments effective on April 1st require you to translate your policy into any language that's spoken by at least 10% of your workforce. Okay, so let's move on to the next big news in California in 2016. That was the Fair Pay Act, Labor Code Section 1197.5, which was effective January 1st, 2016. The Fair Pay Act revises and expands previous California law relating to gender pay, inequality, or disparity, and provides greater protections than those available under federal law. In fact, the Fair Pay Act is probably the strongest equal pay act in the United States. So what changes does the Fair Pay Act make to existing law, at least in California? First, it changed the requirement of equal pay for equal work to a new requirement of equal pay for substantially similar work. Second, the new law removed the same establishment requirement under the old law, thus allowing employees equal pay at different work locations. And this can be a real problem if you have different work locations in different socioeconomic areas, in urban and rural areas, suburban areas, such as we have here in California, where the pay rates are vastly different. What else does the Fair Pay Act do? Well, it narrowly defined bona fide business exceptions other than sex, limiting an employer's defenses in differentiating on pay between male and females on education, training, and experience. But there's a caveat to that. The employer must demonstrate that the factor is not derived from a sex-based differential in compensation, is job-related, and is consistent with a, quote, business necessity. But what is this business necessity? Well, the law defines business necessity to mean an overriding legitimate business purpose such that the factor relied upon effectively fulfills the purpose it's supposed to serve. And importantly, this defense is non-applicable where the employee can demonstrate that an alternative business practice exists that would serve the same business purpose without producing the wage differential. And it's important to note here that under the law, the burden of proof for the business necessity exception is on the employer. What else does the Fair Pay Act do? Well, the fourth major change in the law is that California's Fair Pay Act imposes strong anti-retaliation provisions to protect employees who simply ask about wage differentials, and of course those who invoke the Act's protection. So the Fair Pay Act requires pay equality now, actually for the last 6 months or so, and the employers must maintain records of wages and wage rates, job classification, and other conditions in terms of employment of all employees for a period of 3 years under the new law. So let's delve a little more deeply into the Fair Pay Act, because it's had huge implications for California employers trying to comply with the Act. So what should employers do to make sure they're in compliance with the new law? Well, employers are prohibited from paying any of their employees an amount less than employees of the opposite sex for substantially similar work. So what is substantially similar work? Substantially similar work means a composite of skill, effort, and responsibility that's performed under similar working conditions. It doesn't have to be the same exact job title or the same function or even in the same location. It's the employer's burden to show there's no disparity in wages or similar work, for substantially similar work. Paying different wages to employees of different gender who are performing substantially similar work can only be justified if the employer can demonstrate that the pay difference is based on a seniority system, a merit system, a system that measures earnings by quantity or quality of production, such as a sales position, or a bona fide factor other than sex, such as education, training, or experience. And you, as the employer, will need to demonstrate that the factor is not gender-based, is job-related, and is consistent with business necessity. Now, let's focus a little more on business necessity. What is business necessity? Well, it's defined under the Fair Pay Act to mean that the employer has an overriding legitimate business purpose, and that the factor upon which the employer relies effectively fulfills the business purpose it is supposed to serve. If the employee can show that an alternative business practice exists that would serve the same business practice, but without creating the pay disparity, the employer can't rely on this defense. Now, as I discussed a couple of minutes ago, there's a problem in a lot of states where you have geographic locations in different socioeconomic regions, in rural areas, et cetera. For instance, in California, you may be paying a retail employee more per hour in Los Angeles or San Francisco than out, say, in Fresno or out somewhere in the desert due to the cost of living standard. So what can an employer do with respect to geographic differences as well as with respect to shift or hour differential? What if employees don't work in the same establishment or even in the same geographic location? Well, under the Fair Pay Act, employees can compare themselves to employees working in different geographic locations. And it's the employer's burden to show that a pay difference based on different geographic locations, different shifts, or different times of day is consistent with business necessity and is job-related. As an example, an employee may argue that an employee in Bakersfield may be paid less than an employee in San Francisco if it can justify the geographic location as a bona fide factor. Actually, this should say the employer. Importantly, under the new law, pay secrecy is prohibited. So employers in California, at least, cannot prohibit employees from disclosing their wages to other employees, from discussing other employees' wages, from asking another employee about somebody else's wages. However, if you are asked as an employer about these issues, you don't have an obligation to disclose the wages of other employees. Employees can ask each other, but as an employer, you don't have to give an answer if you, as the employer, are asked. And of course, you can't prevent an employee from exercising their right under the Fair Pay Act. So what are the remedies if you're found to be in violation of this new law? Well, employees can, of course, file complaints with the DSLE, which is empowered to investigate and enforce any payment owed as a result of wage disparities due to gender. The Department of Industrial Relations or the DLSD can bring civil actions on behalf of the employees and other similarly situated employees to receive unpaid wages for additional liquidated damages or for costs. And there are also civil remedies provided for under the Fair Pay Act. Employees can bring civil actions for the amount of wages they feel they were not fairly paid, for an equal amount as liquidated damages, for interest, for cost of suit, and importantly, attorney's fees. A lot of litigation, employment litigation in California is driven under FEHA by the fact that attorney's fees are supposed to be awarded to the prevailing party. Employees routinely receive attorney's fees when they prevail on FEHA claims, but there was recent case law stating that employers are not to recover, and most judges out here will not allow employers to recover attorney's fees when they're successful. There's a 2-year statute of limitation on these civil remedies, 3 years if the violation is found to be willful. Employees also can file civil actions for reinstatement of their position if they've been retaliated against or discriminated against, for asserting their rights, for protected wage discussion, for reimbursement of lost wages, for interest, and for equitable relief. There's a 1-year statute of limitations on these claims. Now, the Fair Pay Act also imposed new record-keeping requirements for employers in California. Employers must keep now for 3 years instead of for 2 years wages and wage rates for all employees, a record of job classifications, and all other terms and conditions of their employees' employment. So what's an employer to do? Well, first, you should probably examine rates for the same or substantially similar jobs to make sure employees are being paid equally. And how can you do this? Well, you can set up what's known as a comparator group. Try to group all employees, if you can, of the same gender who do substantially similar work into a comparator group. Look at their skills, their efforts, and the responsibilities of the job, as well as their working condition. So, for example, if male employees of the comparator group are paid more than female employees in the same comparator group, then a gender pay disparity may be present. And if there is a gender pay disparity, you need to review the factors, the 4 factors, to determine if the pay differential is justified and accounts for the pay difference, or if gender discrimination is really accounting for the pay difference. What else can you do? Well, employers can make sure that all compensation decisions are based on objective consideration, including increases for retention purposes, discretionary bonuses, and the like. And when you're doing this, when you're looking at compensation, remember that compensation doesn't include just straight salary or wages, but includes all forms of compensation, such as bonuses and commissions, as well as benefits. You should document all compensation decisions and include why the decision was made. So include relevant factors such as market factors, geographical location, experience, and the like. Employers probably should also review all their job descriptions to make sure they support the salary decisions that are made and actually reflect job duties, functions, skills, and responsibilities, because job duties change over time, positions change over time, and employees switch positions or do perform more than one function as time goes on. Employers should also make sure they don't discipline employees who discuss their wages with others. And you should probably also review your employee handbooks in case you have any prohibition in there currently prohibiting employees from discussing their wages with others or asking about other employees, asking you about other employees' wages. Because remember that while an employee can ask about wages, you are not required to disclose the wages of other employees. Employers should make sure they train their hiring managers and others to make sure that salary-related decisions comply with the Fair Pay Act, and update, if necessary, your record retention practices to make sure you're accounting for the new 3-year record retention requirement. Employers should also make sure they prohibit retaliation against employees for asserting rights under the Fair Pay Act, and make sure there's a reporting mechanism in place. This reporting mechanism can be part of your EEO policy and can be put in your employee handbook. Now, this is a pretty tall order, but you can bet that the plaintiffs' lawyers out there in California already are planning individual and class actions just as soon as they find the right plaintiff. So who's the right plaintiff? You might wish to prioritize your compliance efforts by reviewing employees who have a high wage gap, such as sales, production, transportation, and professional positions, employees in the financial, insurance, real estate, manufacturing, and healthcare industries, educated, older, and minority women. There's some new legislation that just came out this month that also impacts the Fair Pay Act. That is AB 1676, which was approved by the California Assembly only a few days ago as part of the California State Assembly's continuing efforts to close the gap between men and women. Now, this bill was vetoed last year, but we're back with it again. And under AB 1676, employers will be prohibited from seeking an applicant's past salary history. But, however, the bill further raises the stakes by requiring employers to provide pay scale information to job applicants upon reasonable request. And what's the reason for this? Well, according to economists at Carnegie Mellon, 51.5% of men, but only 12.5% of women negotiate for higher salaries when receiving job offers. And because the starting salaries significantly affect raises and future salaries, studies show women who do not bargain lose as much as $750,000 for middle-income jobs and $2 million for high-income jobs over their career. So we'll see if this gets passed by the California State Senate and if Governor Brown will actually sign the bill this year. Something also new, obviously, federally as well as in California, is that under the new U.S. Department of Labor regulations, the FLSA's white-collar exemption will rise up to $47,476 per year, or $913 per week, which is about $5,000 or $6,000 higher than California's present salary exemption. My understanding is that the congressional Republicans are going to try to kill this regulation, so we'll see if this actually goes into effect on December 1st, 2016. But it's something to look out for because previously California was almost double the overtime pay regulation, the white-collar salary exemption, than was federal law. Okay, let's move on to California's paid sick leave law and what the changes are for this year. As many of you know, hopefully, effective July 1st, 2015, California mandated virtually all employers to provide workers, including part-time workers, with a minimum of 3 days of paid sick leave each year. And so what's new since the law went into effect is that the Labor Commissioner published in late 2015 a list of frequently asked questions. Now, the answers, of course, that the Labor Commissioner provides aren't binding, but they do offer some guidance as to the Commissioner's enforcement position. In addition, the California legislature passed additional amendments to the Paid Sick Leave Act, which became effective on July 13, 2015. These amendments allow employers with unlimited or undefined leave banks to indicate unlimited on the employee's itemized wage statement because you're required under the paid sick leave law to indicate the amount of time available and the amount of time that's been used for sick leave. The amendments also provide that the employer is not obligated to inquire into or record the purposes for which the paid leave is taken. What else do these amendments do? Well, they allow an employer to use a different accrual method than the 1 hour per every 30-hour weeks method, provided that the accrual method is on a regular basis, and so the employee has less than 24 hours of accrued sick leave by the 120th day of employment of each calendar year or in each 12-month period. The amendments also provide that the accrual requirements are satisfied if the employee can use 24 hours or 3 days of paid sick leave by the end of the 120th calendar day of employment. For those employers providing paid sick leaves by a lump sum method, the employer can provide the full amount of leave at the beginning of each employment calendar year or 12-month period. And of course, for those employers who had paid sick leave policies in place before January 1st, 2015, you can continue to use that policy in compliance with the paid sick leave law as long as the employees have 1 day or 8 hours of accrued sick leave within 3 months of employment each calendar year or 12-month period, and the employees are eligible to earn 3 days, excuse me, or 24 hours within 9 months of employment. The amendments provide you're not obligated to inquire into or record the purposes for which paid sick leave is taken, and that you can calculate paid sick leave either using the regular rate of pay for the work week in which the sick pay is used, or by a 90-day look-back period if the employee has different hourly rates, is paid on the commission or piece rate basis, or is a non-exempt salaried employee. Now, Los Angeles, as well as San Francisco and Oakland, have changed the amount of days that must be granted by an employer for paid sick leave. Effective July 1st, 2016 in Los Angeles, that is the city of Los Angeles, not in unincorporated county areas or other cities in the county of Los Angeles, but if you have a location in the city of Los Angeles, effective July 1, 2016, employers with more than 25 employees must accrue for 6 rather than 3 paid sick days. Employers with 25 or fewer employees have until July 1st, 2017 to provide the 6 days, the 6 sick days. And also, the number of days that can be carried over into the next year increases for City of Los Angeles employees from up to 72 hours or 9 days. And importantly, even if you're located outside the City of Los Angeles, if one of your employees works for at least 2 hours within the city in any given week, the time worked in the city must be paid at the city's minimum wage of $10.50 an hour and must accrue paid sick leave of 1 hour for every 30 worked as paid sick leave. So Los Angeles is following the lead of other large cities in California, including San Francisco and Oakland, that have already raised to 6 the number of paid sick leave, paid sick leave days which an employee may accrue. Now, not to be confused with the Fair Pay Act, California also has what's known as the Fair Days Pay Act. And what is this? Well, back in 2011, Governor Brown signed the Wage Theft Prevention Law. And this law, which was effective January 1st, 2012, required private employers in California to provide written notice to all non-exempt new hires of employment information, including the employer's legal name, the employer's physical address, payroll dates, the employer's working compensation carrier, and wage rate and basis of pay for the new employees. And the Department of Labor in California has actually put out a form that you can use. So what's new for 2016? Well, SB 588 is aimed at cracking down on wage theft by giving the Labor Commissioner some pretty tough new enforcement rights against employers who, quote, steal employees' wages. So what's wage theft? And I'm actually seeing plaintiffs' employers use the term wage theft in complaints and threaten criminal prosecution, although I'm not aware of any criminal statute or penalties covering this. So wage theft is what's happening when employees are working piece rate or off the books, when employees are forced to clock out early and keep working, or to work before they clock in, when they're forced to clock out or clock back in from a meal period but are actually working, when their tips are stolen, and another example is when employees don't actually receive meal or rest breaks at all. These are considered wage theft. So wage theft really is the illegal holding of wages by an employer that are lawfully owed to the employee. and it's defined by statute to including failure to pay overtime, failing to pay the minimum wage, making unlawful deductions in employee pay, in other words, anything that's not been authorized, forcing an employee to work off the clock, or not paying an employee for all hours worked, another variation of off-the-clock work. So how does SB 588 change the law that's already been in effect for over 4 years? Well, it gives the Labor Commissioner pretty strong enforcement rights. The Labor Commissioner has the right to use any of its existing remedies available to a judgment creditor and to act as a levying officer when enforcing a judgment. The Labor Commissioner under SB 588 can actually place a lien on the employer's property or levy on the business's bank accounts or accounts receivable. And if the aggrieved employee incurs attorney's fees, the Labor Commissioner can include those attorney's fees in the lien or the levy. It's a pretty tough statute. In addition, SB 588 prevents employers from closing down a business and then reopening under a new name in order to avoid debt for wages to workers. Under SB 588, any new business that is, quote, similar in operation and ownership, unquote, to the non-paying employer also is liable for the wages owed. Now, when is the new business considered to be the same employer for purposes of liability? Well, a new business will be considered the same employer for purposes of liability if the employees of the new employer are engaged in substantially the same work, in substantially the same working conditions, or to substantially the same supervisors. In other words, basically, you just change the name on the door. Or where the new entity has substantially the same production process or operations, produces substantially the same products, or offers substantially the same services, that has substantially the same body of customers. And this can happen not just where you change the name on the door to escape liability, but when there's a change of ownership, there's a sale of a business, or there's a merger. Also under SB 588, an employee can bring wage theft claims against the owners of the employing entity as well as anyone else who acts on behalf of the employer. And here's the really important part, because SB 588 effectively creates individual liability in California for wage and hour violation, because now the employee can bring a theft claim, a wage theft claim, against someone who's acting on behalf of the employer, such as an owner, even though the owner may not be the corporation, or a manager, or someone like that. And moreover, as a result of SB 588, the Labor Commissioner can go in and seize the personal property and bank accounts of individual owners and others who violate California wage and hour laws. This is a pretty tough law. But that's not all. The law goes even further. Once the Commissioner finds an employer to have engaged in wage theft, the Labor Commissioner can now require that employer to post a bond to continue doing business in the state from $50,000 to $150,000. And if you don't post the required bond, you can have your business license revoked. In addition, the new law imposes, or at least it authorizes, civil penalties for wage theft violations, in addition to wages owed and attorney's fees. And the penalty is $2,500 for the first offense and $100 for each calendar day the employer continues to do business in violation of the law, up to a maximum of $100,000. Continuing on in this area of what's new in wage law in California, as you hopefully know already, on January 1st, 2016, the California state minimum wage increased from $9 per hour to $10 per hour. Now, certain California cities have higher minimum wages. San Francisco, it's $13 an hour. In San Jose, it's $10.30 per hour. And we can anticipate that the minimum wage in California will be $15 by 2022. And we were talking about the federal regulation for exempt, non-exempt. Well, in California, the minimum salary requirement for exempt employees increased up to $41,600 per year, or still $6,000 or so less than the anticipated federal regulations go into effect in December of 2016. And note that for computer software professionals, this minimum salary requirement is higher, or $87,185.14 per year. I don't know if anyone on the phone is interested in the new regulations and laws regarding piece rate compensation, which affect, for instance, growers, affects auto repair businesses and auto dealers and the like. So we'll go through these pretty quickly. And also there was a U.S. Supreme Court case that came out the other day resulting from the downtown LA Motors case out here in California dealing with this issue. But effective January 1st of this year, California Labor Code 226.2, a new law, rewrote and redefined the rules governing piece rate compensation in California. And again, although it primarily applies to agricultural interests and auto servicing, it also applies to all piece rate compensation plans. So what's the key issue here for the piece rate people under the new law? Well, if you're paying on a piece rate basis, you now need to make sure that employees are separately compensated for time spent taking rest breaks for other non-productive time, and you must provide information on the wage statement requiring these times. That wage statement information has to include hours spent on rest breaks, the rate paid for such rest breaks, because employees now must be paid for this time even if they're piece rate workers, gross wages paid for rest breaks, hours spent on other non-productive time, a rate paid for non-productive time, and the gross wages paid for non-productive time. This all must be on the wage statement for piece rate workers. Also, rest and recovery periods must be separately compensated and must be no less than the greater of the applicable minimum wage or the average hourly rate for all hours worked, exclusive of break time, during the work week. The law provides you with an affirmative defense for failure to compensate piece rate workers if you can satisfy the following requirements by December 15, 2016. You make payments to current and former employees to compensate them for break and other non-productive time that you didn't compensate them for properly from July 1st, 2012 through December 31st, 2015. You make a good faith effort to locate and provide these payments to former employees who would qualify, and you provide written notice to the Department of Industrial Relations by July 1st, 2016 of your intention to make these payments. So you only have a week or so left to notify the department if you're going to try to fall into the safe harbor rule. So just as a final word on this, employers who are paying employees on a piece rate basis may wish to pay them the minimum wage for all hours worked and use an activity-based bonus to compensate them otherwise. And the new legislation doesn't change or impact overtime rules or requirements. You're still required to pay overtime and provide meal breaks and rest breaks. Some other perhaps not as significant changes in California law for 2016 were implemented regarding E-Verify. It's now a violation of California law to use E-Verify in a way not required by federal law to check the employment authorization status of an existing employee or of an applicant who has not been offered employment. You can still use E-Verify to check the employment status of a person who has been offered employment, and note that the civil penalty here is pretty high. It's $10,000 for each violation. As you probably know, if you do business in California, California also requires school leave, unpaid time that is, for employees. Labor Code Section 230.8 has been amended to require employers with 25 or more employees to provide up to 40 hours of leave per year to employees who are parents, guardians, or grandparents of children enrolled in the licensed daycare facilities in grades K through 12 for the purposes of participating in school activity. The new law now defines covered employees to include step-parents and foster parents and expands coverages for absences to include activities including finding, enrolling, or re-enrolling a child in school or in a daycare, or for attending to child care emergencies and school emergencies. Okay, in the time we have remaining, let's turn to what's new on the litigation front in California. Many of you are familiar with PAGA, the Private Attorney General Act. It gives private citizens the right to pursue fines under the Labor Code, in this case, that normally are only available to the state of California. Under PAGA, employees are allowed to seek civil penalties not only for violations that the employees suffered, but also for violations of current or former employees. And importantly, in the Iskanian case, the 2014 case, the Cal Supreme Court ruled that an employee's right to bring a PAGA action may not be waived in an arbitration agreement. Now, the U.S. Supreme Court has denied several petitions for cert in this case and in others, challenging the decision in 2015 and 2016, but with the new U.S. Supreme Court, we'll see what happens with that. Also, on the PAGA front, in the Stockholm versus Luxottica case, the Ninth Circuit upheld the California Supreme Court standard and ruled that employers cannot enforce provisions in arbitration agreements that require employees to waive their right to bring PAGA claims. But this decision paves the way for workers to bring labor code claims on behalf of themselves and others against employees in court proceedings, even when they're arbitrating their individual claims in a separate action. So under this decision, you can have two cases going, one in arbitration and one in superior or federal court for labor code violation. And the court claim will include the PAGA claims, even though the other claims are proceeding in arbitration. And I alluded earlier to this case, the Williams versus Chino Valley Independent Fire District case, a 2015 for the by the California Supreme Court, and it ruled that the prevailing employer has to prove that a workplace bias suit is objectively groundless before it can recoup litigation costs in a FEHA case. Okay, last but not least, many states have passed medical marijuana statutes or have passed, such as Colorado, recreational marijuana use statutes. And in California, the recreational use, I think it's going to be, it will be on the bill in November, it will be on the, on the ballot in 2015 to try to make marijuana legalized for recreational purposes in California. So, you know, what happens with employers' anti-drug policies? Are they up in smoke? Well, as of the date we prepared this slide earlier this year, 23 states, including California, District of Columbia, and the District of Columbia have legalized marijuana for medical use, and 4 states, most notably Colorado, have legalized marijuana for recreational use. In California, this law is codified under Health and Safety Code 113625, the Compassionate Use Act, 1996. But despite these state law trends to decriminalize marijuana use and possession, marijuana remains a Schedule I drug and is a narcotic under the Federal Controlled Substance Act. The possession of marijuana, therefore, even by licensed medical users, let alone recreational users, is unlawful under federal law. And to date, courts in most states, including the California Supreme Court, relying on federal law, have upheld the termination of employees using marijuana legally under California law. For instance, in Roth versus Waging Wire Telecommunications, a 2008 case, the Cal Supreme Court upheld the termination because the Compassionate Use Act does not eliminate marijuana's potential for abuse or the employer's legitimate interest in whether an employee uses the drugs. The California Supreme Court held that a plaintiff can't state a cause of action under the California Fair Employment Act and Housing Act, FEHA, based on the employer's refusal to accommodate an employee's use of marijuana for medical reasons or for wrongful termination of employment in violation of public policy. Again, relying on federal law because employers if marijuana remains illegal under federal law, and under this ruling by the Cal Supreme Court, employers are not required to accommodate marijuana use, even where the employee is using medical marijuana or soon to be maybe recreational marijuana at home. And to date, California courts relying on federal law have upheld determination of employees using marijuana legally under California law. Here's a federal case, James versus City of Costa Mesa, where the Ninth Circuit held that while medical marijuana use may be permissible under California law, users are not entitled to protection from discrimination under the American with Disabilities Act. Now, as we sit here today, FEHA currently places no duty on an employer to accommodate an employee by authorizing the use of medical marijuana. And although California law allows employers to have zero-tolerance drug policies and to fire employees who fail drug tests, you need to still satisfy state law regarding the use of drug testing of prospective and current employees. You cannot just randomly perform drug tests on employees. And in the minute we have left, let's just talk about the type of drug testing that's allowed in California. You can use drug testing as part of a pre-employment screening, as part of a physical examination, where you have reasonable suspicion that the employee is using drugs, as part of post-accident testing, or in really limited circumstances, as part of a random testing of employees in a strictly regulated industry or in a position critical to public safety or the protection of life, property, or national security, but not the pursuit of happiness. So what can you do to make sure you're in compliance? Well, you can establish a drug-free workplace policy, post it in your workplace, and make sure you include it in your employee handbooks. Make sure you're in compliance with state and local laws when conducting drug testing, and update job descriptions of safety-sensitive positions to include a no-drug policy. I know that this webinar will be available on the internet, on TC Intranet as we discussed, and if you send an email either to myself, jviola@thompsoncoburn.com, or Irene Rosey, I-R-O-S-E-Y, @thompsoncoburn.com, we can provide you with a copy of the slides. If you have, next question, regarding FEHA, we have 61 employees, but only 2 in California. Yes, make sure those 2 employees get the harassment training they need. Can an employer have a policy that pay cannot be discussed during work hours while on the clock? Employees would not be prevented from discussing pay during meal breaks or before or after work. I think that's going to be a tough policy to enforce, but I think you could have that policy that, well, let me take that back. It involves employment, so I don't think you should have that policy. I think that's a policy that will be looked at quite critically by the California Department of Labor. Last question's coming in here. California unpaid school leave up to 40 hours. What does this mean? This means that you may allow workers up to 40 hours of unpaid leave to attend to school activities as we discussed previously. So they don't have to be paid for it. They can take vacation if they want to, but you don't have to pay your employee for participating in a child's school activities, or to help search for a new school, or to change schools, or to attend to child care emergencies or school emergencies. You have to let them take up to 40 hours off for those issues, but you don't have to pay for it. And I thank you very much for your participation. Thank you, and have a great day.